Hello.
Hi Arun, welcome.
Hi.
Yes, Nabinai madam, good evening.
Hello.
Hello. Good evening, good evening.
Good evening. So I am not able to connect using my computer. So for now, I joined using the phone.
Ma'am, there's a meeting ID number.
Huh.
If you have the app downloaded on your computer, you can just use that meeting ID number and the password.
So that's what I'm trying to do now. Is the meeting ID number 933599259?
That's right.
Correct.
Yeah, so I tried that. It's still not working.
And the password is 128846.
Okay, so I will try again now.
Because that link is problematic, it's not working. You have to.
Yeah, the link is not working. I think Srinjoy got lucky.
Srinjoy is not there.
Oh, but he messaged saying he is connected.
Okay.
In fact, he sent me the link on my Gmail, sir.
Arun, you may want to fix the computer a little higher. Otherwise, it's looking at the ceiling. So.
Oh, okay.
Enjoy Banerjee, raise hand.
Is this better, man?
Yeah, but why Srinjoy is not there still?
Because he's the one who said he is connected first. So you may want to just check with him on why.
I'll do that.
Yeah. Can you hear me?
Yes, good evening.
Good evening. Good evening.
So we all are four are there. Now it's 4:59. 1 minute more.
And 40 participants.
Yeah.
Okay.
40 have already joined.
Fantastic.
Hi, Srinjoy.
Hi.
I'm still, I'm trying to still coordinate the computer. Otherwise, for now, I've joined from my phone. That's right.
Understood.
Yeah.
So we're already visible to the participants.
Yeah, we are.
Everyone know.
Yes.
Sorry, can somebody repeat the meeting ID again? I restarted the computer. That's the only solution which works most of the time. So 9.
1 second.
Arun, you are helping out?
I'm just trying to pull it up, sir.
Yeah.
Yeah, same here.
It's 9335
9335
99259.
99259. Let me see if it works now. I have been doing Zoom calls every day. I don't know what is happening today. It's just, yesterday we were on it for 3 hours. Maybe that's why it's not allowing me to connect now.
There's a chat window where the password has been put out as well.
Yeah, but it didn't ask for a password till now. So
Okay.
I'm trying through my app. So let me see if it comes to the password page next. Because otherwise, the last 3 times it did not move beyond this page. So. No, it's not going beyond this. I don't know why.
Maybe you could try restarting it, ma'am.
I did that. I just did that. I restarted the comp, but it's not working. There's some other problem. I don't know what.
So, ma'am, will you be comfortable on over the phone for 2 hours?
I'll figure out. Yeah, not to worry.
So, shall we start?
Yeah, sure.
Chalo, that's fine. Hello, friends. I am Manoj Sonawala, host for today's second session of the online fireside chat series organized by IMC along with Manoyog GSC Advisors Private Limited. And I welcome you all to the today's session, which is on dissection of Personal Data Protection Bill 2019, wherein speakers will discuss on various aspects, impacts, and action points while discussing the bill. For giving us guidance, clarity, and possible action required from our side, we have with us 3 experts from the data protection world. Ms. N.S. Nappinai. Ms. Nappinai is a Supreme Court advocate and founder of Cyber Saathi. She is a senior and renowned lawyer with about 3 decades of rich and varied experience, specializing in constitutional, criminal, IPR, and cyber laws. She is an advisor of Maharashtra Cyber Police and amicus curiae before Supreme Court in Rajwala versus Union of India to formulate methodologies to remove child sexual abuse material and violent videos of offences against women from online platforms. Ms. Nappinai is part of government committees dealing with various policy issues on cyber laws. Ms. Nappinai has presented before the Lok Sabha Parliamentary Committee on Women Empowerment on Cyber Safety Online 2020. She has presented before the National Cyber Security Center, part of the Prime Minister's Office, on India's proposed National Cyber Security Policy 2020 to 2025. She is on government committees as expert on cryptocurrencies and blockchain, amendments to Information Technology Act 2000, that is IT Act, and electronic evidence. She contributed extensively to the drafting of India's Commercial Courts Act 2015. Ms. Nappinai was an expert member, Tamil Nadu, for State Child Policy Committee 2015-16 for formulating the cyber security aspects under the state child policy. An alumni of Stanford CDDRL, Kevling UK, and IVLP USA, Nappinai trains judges, police, armed forces, and intelligence agencies at national and state academies. She is a most sought after speaker at national and international conferences. She has given an inspirational TEDx talk on being fearless and showing up. Ms. Nappinai is a prolific writer who often contributes on leading publications and has authored the seminal book on cyber laws titled Technology Laws Decoded. Her books on cyber safety and emerging technologies is forthcoming in 2020. Welcome, Ms. Nappinai.
Thank you.
We have with us Srinjoy Banerjee. Srinjoy is a lawyer by profession with nearly 20 years experience in data protection laws, IP litigation and prosecution, information technology and cyber laws, among others. Srinjoy founded India's first techno-legal advisory and consultancy in data protection, privacy and IP, Excalibrancy, in 2018. The value proposition of his organization is to crunch down legalese while providing advisory and consultancy for comprehensive solutions in the areas of privacy, data protection, and IP. Over the years, Srinjoy has gradually metamorphosed from a core IP professional to a privacy professional and is extensively working on data protection laws currently. Prior to setting up his techno-legal organization, Srinjoy served as an in-house counsel on IP and data privacy for a global professional service organization. He was also a paid partner with an IPR firm. Srinjoy is a certified information privacy professional in Europe, a certified information privacy manager, and a fellow of information privacy from International Association of Privacy Professionals. He has also undertaken the certification for and is a Data Security Council of India certified privacy lead assessor. He is closely associated with the International Association of Privacy Professionals. He is a co-chair of the Delhi chapter. He is also a regular speaker on data privacy at the IAPP Knowledge Nets and at multiple national and international forums. Srinjoy is an alumni of Delhi Law Faculty. He also holds an MBA in Information Technology Management from AIMA. The belief behind starting Excalibrancy is a journey into balancing of rights of various seemingly conflicting fields in the space of intellectual property rights, cyber laws, and data protection. Also, his experience with both intellectual property rights and data protection makes him uniquely qualified to understand and blend the nuances of both. If data be the future, both these fields need a merger. Right. Welcome, Mr. Srinjoy.
Thank you. Welcome all.
Now, last but not the least, Mr. Arun Sadanand Prabhu is a partner with the Bengaluru office of Cyril Amarchand Mangaldas, and he is part of the technology, media, and data protection practices. Arun has been ranked as an upcoming lawyer by Chambers and Partners 2020. Further, clients have complimented him for his extremely impressive understanding of the subject matter, as well as his cogent advice and the way he thinks outside of the box. Arun advises extensively on matters relating to data protection and privacy, including issues surrounding data collection, processing, data mining, protection, and retention, in addition to the formulation of policies and best practices designed to mitigate the legal risk associated with handling of data. He offers sector-specific cutting-edge advice to clients handling sensitive data such as hospitals, banks, and financial institutions, and assists them in complying with the extensive guidelines issued by regulators, including the Reserve Bank of India, Insurance Regulatory and Development Authority of India, and Telecom Regulatory Authority of India. He writes, speaks, comments, and consults extensively with various industry and government bodies in relation to developments in the rapidly evolving data protection space in India, including on the right to privacy and other judgments, Personal Data Protection Bill 2019, intermediary guidelines, e-commerce policy, and various white papers and circulars released by TRAI and Department of Telecommunications. He has, in conjunction with the Bombay Chamber of Commerce and Industry, submitted detailed responses to the draft e-commerce policy and the draft information technology, that is intermediary guidelines amendment rules 2018, to the Department for Promotion of Industry and Internal Trade and to the Ministry of Electronics and Information Technology respectively. He has also authored a number of articles on issues surrounding data privacy for India Business Law Journal, Data Guidance, and FICCI Chem Entertainment Law Book 2019. Welcome, Arunji.
Thank you, sir. Welcome, everyone.
Now, See, I have introduced each speaker. Each speaker will appraise us on basics to set the tone in the areas of their respective expertise, with their opening remarks taking around 5 to 7 minutes each. And thereafter, I will raise few questions or queries on behalf of all the participants. Now, meanwhile, if you have any queries or need any clarification or guidance, you may send your queries through Q&A button or in chat mode. If you need to speak to any of the speakers, please press hand button on your screen. Time permitting, we will allow you to raise your query orally. By any chance, if you don't get opportunity to speak or raise your query, you may send the same to me on contact details shared in the circular of this session. So over to Ms. Napinai to start with. Thank you.
Thank you, Manoj. When I was thinking about, I keep getting this question often in terms of what is your opinion on the data protection draft bill? And I always sum it up with one word: a wildebeest. When the myth goes that when the wildebeest was put together, it had a little bit of many animals, and therefore it doesn't really qualify or categorize as one single kind of animal. In a way, that's what the PDP bill of 2019 seems to have ended up as. It started off in a very simple manner with respect to the 8 data principles that we are familiar with already for data collection and processing, which is consent for collection, receiving, retention, dissemination, destruction, etc. But today what we have is we have a law which is meant for personal data protection. It does not deal with commercial data. It's meant for personal data. It is also not meant to involve non-personal data or community data. Justice Sri Krishna's committee clearly said that we should have a law for non-personal data, but it should be separate. It also was meant to primarily have a focus on protecting personal data by putting the data subject, the principal, in the middle. It was it decided to follow the GDPR process, but not completely. And in that process, it has adapted a lot of things which are not necessarily very positive also, even under GDPR. You will hear a lot said with respect to how GDPR is a golden standard, but I would beg to differ because of the very complexity of the way the regulation is formulated, the General Data Protection Regulation of the European Union, and the fact that it expanded the scope of permissibility in terms of usage and processing. And I will come to that in terms of pinpointing, according to me, what are the issues also with respect to the data protection bill. But anyway, so by just adapting very blindly, not realizing that till date, India does not have a robust data protection regime. Contrary to perception, we do have a data protection law, but a very minimalistic one under 43A in the Information Technology Act. So when I say IT Act going forward, I mean the Information Technology Act and not income tax, just as a qualifier there. Anyway, going forward, so we did have 43A, we did have the rules that were formulated under 43A, which broadly adapted those 8 principles from the EU and the UK data protection laws. It's just the implementation of those rules that was wanting. We had provisions under 46 for people for whose rights were violated to go before the adjudicating officer, who even till date is the Secretary, Ministry of IT. You don't hear of any cases that went that far. Far and few in between will also be primarily focusing on financial frauds and the consequent backlash in terms of whether there was a data breach resulting in financial frauds, but not simplicity violation of 43A. From such minimalistic laws, we jump straight to GDPR. When you look at the global trends, they did have an evolutionary process. They went from just protecting in terms of consent and how that consent can be used to processing beyond consent. We have moved directly to a regime of processing beyond consent. And my concern with that regime is, to what extent do we socially and culturally understand even the construct of personal data protection? How much are we really going to value personal data protection? And to what extent are we going to really help in its implementation? Very, very quickly, what I would like to touch upon going forward is, one, the issue which I have with GDPR carried forward to the data protection bill is the concept of profiling. So contrary to perception, considering that we have already seen enough backlash of profiling of individuals, Cambridge Analytica just being one example, of the US elections, which is still a moot issue out there. The concern that arises when I read the PDP bill draft is that profiling is not only permitted except where it is restricted or limited by the Data Protection Authority. It is also to some extent permitted against children. Obviously, it doesn't seem like that was the intent behind the draft. It may just be something the draftsman may have missed. So before the bill comes through, I hope that they rectify this particular aspect. The issues with respect to the exemptions that are given, especially for the government, is a big cause for concern. Data localization is much diluted. Offenses under the Act are much diluted. And I would say it's a good thing with respect to offenses. Data localization, we will park that issue for now. I would like to end my opening statement with this. You know, COVID has given us a lot of time to catch up on television, right? I went back to one of my old favorites, Yes, Minister. And this is, you know, I may be giving away my age when I say this, but this was something that came out when I was in school. My co-panelists may not have been born around the time when it was released, probably. But anyway, I was in school when it first came. And there is this one episode there about the National Citizen Registry. And the whole topic of discussion in that episode is about what is it that the citizen has a right to with respect to data protection. And should the government really look into protecting and limiting the processing aspect of this registry. I would strongly advise everybody who is part of today's call to go back and watch this episode. It is amazing because something from 1982 or so is so relevant and valid, and everything seems to be status quo even today.
Okay, Srinjoy, can you please take over?
Yeah, sure. Thanks, Napana ma'am. That was pretty well summed up, so to speak. So to add to what ma'am was saying, I think I would in fact agree with her. The water, as they say, is pretty muddied right now because the way Justice Sri Krishna had formulated it, there were some concerns, but it was, as per law, it was sound. Now it's got pretty muddied. If I was a conventional practitioner, I would have been more than happy to have this bill, because the whole point is that there are so many gray areas. They are just a gold mine for me. But we as I think all of us on this panel are not really conventional lawyers. We want the law to at least sound reasonable and at least be reasonable to the extent that is possible. So definitely Justice Sri Krishna's draft was better. I think a lot of it has got lost in translation. maybe words have been taken away, which had a lot of meaning, but now have no meaning given in the form that is there. My prime concerns would be perhaps, yes, there is a need for the PDPB to become a law soon. I don't know. I guess they are looking at the monsoon session. COVID has may push the packet to the end of the year. We don't know. Um, Unlike what Dapana Imam was saying, there is still a heavy reliance, I feel, on consent. And consent in terms of GDPR was supposed to be the last or the weakest form of lawfulness that is there. I would agree with, because one of the prime concerns about consent is that it has the ability to withdraw. The withdrawal of consent is possible. So that is something that we have to look at. Obviously, companies need to start looking at how do we implement it. Awareness is, I think, as Napana Imam was saying, awareness is perhaps going to be very, very important in a country like us. Data privacy has to go beyond what we do in four walls, but it has to go beyond that to the people whom it is concerned with, and which is everybody. And the last portion of the bill that is a point of concern is the lack of accountability. Now, Justice Sri Krishna had talked about accountability as a principle, accountability to be there. Unfortunately, it seems to be missing. And while we go ahead, we can discuss that. So, in short, this is a summary of what I have. Perhaps now Arun can take over.
Thank you, Sanjay. So I actually have a slightly contrarian. That's usually my brief in these discussions. I'll start off with my perspective on this. Like ma'am said, wildebeest, I will say thank God. Thank God, because we actually have an actual data protection legislation in India. Everyone on this call has been doing this for many, many years. And whenever a foreign law firm or a international group sends out a list of around data protection, our response has always been, that there's very limited data protection. It's only protected. A specific category of data is protected, etc., etc. So I, for one, I'm glad that there is at least talk, if not action, in terms of creating a broad-based general data protection regime in India. The second point, and I agree vehemently with my co-panelists here, there are many cracks in this edifice we are trying to build. But the second point I also want to make is that what we are seeing is the tip of the iceberg. Before the data protection, before the GDPR came into force, there was the privacy directive. There were multiple decisions of the European courts, which created a sort of legal framework around it. 2 years before the bill, before the GDPR kicked in, there was a data protection. There was an Article 29 working party which was formed, and that working party sent out reams of guidance on consent, guidance on permissible actions, guidance on anonymization, a treasure trove of guidance, both from legal and technical perspectives around data protection and privacy. And then you had the GDPR come into force, at which point the entire system in Europe almost ground to a halt. You had thousands and thousands of emails inundating people. On the day the GDPR kicked in, there was an assumption that almost 85% of companies in Europe were non-compliant, et cetera, et cetera. So realistically speaking, what we're seeing is the tip of the iceberg in terms of the actual legislation. If anything, I would say that the PDP bill is even briefer about some of the more granular aspects of data protection than the GDPR is. And the GDPR itself is reliant on large parts of detailed delegated legislation and guidance which have come out after it. These blanks will have to be filled in by our Data Protection Authority. And this bill will stand or fall based on how the Data Protection Authority passes codes of practice, how the Data Protection Authority approves privacy by design policies, how the Data Protection Authority does adjudications, how fines are imposed, how people are dealt with. That will determine the viability of this framework. But barring that, I light a candle every day hoping that this Data Protection Authority will act like the European regulators have They will actually send out large volumes of guidance. They will send out polite notes to people saying, "Dear Dash, the systems are prima facie not in compliance. Do you want to consult with us on how you can do these things?" They will probably lead by example in terms of their own practices. I light a candle every day that they will do this. And if they actually will do this, then we may actually have a data protection framework that will effectively govern the single largest group of people in the world, just practically, because this is going to be 1.4 billion people being governed by a single framework, which is far larger than Europe, far larger than anything else in the world. So I, for one, would welcome it. That being said, the devil is in the details, and a lot of us in advising our clients or dealing or navigating our respective enterprises through these fairly thick and muddled waters will have a significant role to play in the evolution of this legislation. Much like competition practitioners and antitrust practitioners in 2003 and 2004 stood at the cusp of a whole new world, we as privacy professionals stand at a cusp of a whole new world when it comes to data protection. And it behoves us to be, at least from my perspective, and I am an optimist, I am optimistic about the fact that we will arrive at a solution which is better than what we're leaving behind, merely because the denominator is so low. Just the existing protection regime is so low and so dilute that I feel even a 50 to 60% solution will be better off than where we were on this until recently.
Thank you, Arun. As you rightly said, execution is the key. When we say the taste of pudding is in eating, similarly, we have every legislation, but the execution plays a major role in success of a legal framework. So going forward now, see, Madam has touched upon few aspects of the PDP Bill 2019, but I would request her to give us briefly the top 3 or 5 issues which would throw focus on during today's entire discussion. So, ma'am, can you please take that?
Sure, Manojji. So to begin with, I would, like to elaborate a little bit more on what my co-panelists have also touched upon, the consent aspect. So, what Arun was referring to as this flurry of emails that all of us were getting just before GDPR was supposed to kick in, was on the misapprehension that people had that consent was mandatory. And it took them about 6 months into GDPR to realize that consent is not really needed for various aspects. Similarly, under the PDP bill, on one aspect, I would beg to differ from Srinjoy on this front, that I would not say that everything was hunky-dory with the Justice Sri Krishna Committee report's draft bill. In terms of wording, in terms of structure, they have done a very good job in 2019 bill. It is in the content and the manner in which certain checks and balances that were there in the Sri Krishna Committee draft of 2018, which has been removed in the new bill, that the issues arise. So when we look at the flow in terms of the provisions pertaining to when consent is needed and when consent is not needed under the PDP 2019, you'll see that broadly it is similar in terms of the 2018 draft and the 19 draft. That doesn't necessarily make one or the other better than either. I would say it is still a matter for concern because it is fairly open-ended, except that if an entity were to resort to, and this is the one addition in the 2019 draft which I really like, which is on privacy by design. Privacy by design was introduced in the 2018 draft, but it read like a policy statement rather than an enactment. They have taken that out, the entire portion, and redrafted it and specifically put in provisions on how policy by design can be implemented. And to that extent, I feel there is excellent clarity with respect to the PDP 2019. So if an entity were to resort to privacy by design in the manner that is set out, and because of that consent is predominantly diluted, one can feel a little bit of comfort. But otherwise, there's various provisions which give you exemptions from the consent aspect has to be evaluated carefully to see what is it that we need to put checks and balances in. And while we are talking about this, I would want to jump to chapter 8, which is what has caused maximum controversy apart from the data localization provisions, which is on exemptions. So the distinction between exempting from consent to exemptions under chapter 8 is as follows. Under chapter 8, the entities, government, particularly their entities, or in the circumstances set out therein, there is an exemption from the provisions of the Act itself. Whereas the exemptions from consent is only with respect to that aspect of taking consent or the limitations that go with it. So the chapter 8, which everybody has anyway flagged already as an issue, needs to be looked at very thoroughly because it's so open-ended. It gives the central government excessive powers in terms of what can be done. The way in which the Data Protection Authority is to be appointed and the kind of powers that are vested in his hands, again, I would say are a cause for concern because he has overarching powers, and I'm using the gender he very open-endedly here. Of course, he equals she. It could be a lady who would be heading the Data Protection Authority for all you know. So if you look at the entire structure of the Act, it gives very wide powers which amount to legislative, judicial, executive, everything in the hands of one entity. So that is a very powerful post which can then lend itself to abuse also. So all the powers that vest in the central government's hands are only diluted very minimally when it comes to taking with consultation with Data Protection Authority, etc. And if the Data Protection Authority is also going to be appointed by 3 government verticals, then it is just the right hand allowing the left hand to act. So these aspects again do not lend themselves for checks and balances. Profiling, which I had already highlighted, when you look at the provisions for child data protection as well as general data protection, the profiling provisions, the very definition of profiling being included and being permitted, and with that power of permission again lying in the hands of the Data Protection Authority, serious cause for concern. Again, one final word in terms of a good call in terms of the 2019 draft is where the offenses have been modified, and only the offense of, you have a provision for de-identification, which means that you can no longer identify the specific individual with respect to the data. So re-identification of de-identified data for the purposes of processing is the only offense that has been retained. All the other offenses which were too open-ended and generic and were bound to cause concern, and of course, more importantly, bound to play havoc with corporates, have been removed. On this note, in terms of additions, etc., a lot of things with respect to the exemptions, and this is what I believe Srinjoy was referring to, a lot of those exemptions were tempered in the Sri Krishna Committee draft by saying that those exemptions will be permitted provided it has been allowed in law passed by Parliament. So that portion of in law passed by Parliament has been removed in the 2019 draft. Finally, I'm going back to the preamble and the primary scope of this provision, which is why I touched upon and emphasized that this enactment is supposed to be for personal data protection. There is a very clear limitation of the scope in section 2 itself, saying this does not apply to non-personal data. However, one small addition has been made, which is not really that small. It says except for section 91, and section 91 has been included as a new provision in the 2019 Act. And when you look at 91, you will realize that a very open-ended provision to permit non-personal data legislations through delegated authority has been included. that is not a very good addition, particularly when the scope doesn't give leeway for this, and the enactment is attempting to delegate something which is not part of the primary legislation. So on that technical note, I will pause here.
Srinjoy, I think you will be having a much more counter arguments to what Madam has said regarding.
So no counter argument except for the fact that consent in terms of the whole consent framework seems to be, in terms of sensitive personal data, in terms of explicit personal data, the exemptions are not being used. The consent will be used. That's point number one. But I do agree that there are certain exemptions that are there, and one of the exemptions is very wide, reasonable purposes, and what that reasonable purposes is also defined very fluidly. To include so many things. So one of the things when I did a comparative, when I had done a comparative, was the fact that in terms of the versus 2018 versus 2019 talked about 2018 talked about the Data Protection Authority having many of the things. Now it has become wider. It has become somebody to have that. So that is a contrary view. But apart from that, I guess in terms of the PBD, that is the privacy by design. Now, globally, how privacy by design is framed talks about, one second, just one second. Globally, how privacy by design is framed talks about, there are seven odd principles that are there, and those principles have to be adopted. One of them being the whole dynamics to that is that it is beyond legal exactly. It's not a policy per se. It is how you frame privacy in an organization. So from the start to the end, there has to be privacy designed in the products and the processes. And that's how, when I go to the clients, that's how, in terms of the telecom clients or in terms of any of these clients. So the seven principles are that: be proactive, not reactive; privacy as the default settings; privacy embedded into the design; full functionality; end-to-end security; visibility and transparency; and respect for users' privacy. Now, my contrary view to ma'am's view is that while in terms of, if you look at a policy alone, in terms of how the bill has been drafted, may contain all of these. But in practice, one of my concerns with clients is, in practice, is that happening, or is it just a document that is getting made? So that is my problem with the law, as the bill as it is drafted right now. Privacy by design is a wider concept than just documentation. In terms of non-personal data, I guess one aspect that ma'am would know better, but there is, I think, a committee that is looking at non-personal data as a subject matter and giving their views to it. My personal view is that there is a very thin line between personal data and non-personal data. Non-personal data should not be part of this bill or act. That is a given. However, there is always going to be a chance of a non-personal data in isolation becoming a personal data in terms of some context that is there, along with some elements of the personal data. It can become as well a personal data. So how do we deal with that? I think should be dealt with in the bill.
Okay. So Srinjoy was talking about, sorry, Srinjoy, you want to say more?
No. Please go ahead.
Yeah, ma'am, you go ahead.
May I just ask
Yeah.
one question? Yeah. See, Srinjoy, if you're saying that how non-personal data should be dealt with in terms of 91 is to be also provided for in this bill, then isn't it contrary to what you said earlier when you said that non-personal data should not be part of this bill?
So I'm saying non-personal data should not be part of this bill. So you're talking about the exemption 91?
Yes.
1 second.
Because the minute you say that, you know, the parameters of how 91 should be applied, because, you know, that's whatever you pointed out is also my point, that you have a non-personal data committee,
Yes.
then why bring in this half-baked provision into the Personal Data Protection Act?
I agree with that. I agree with that completely. That non-personal data should not be part of this bill.
Yeah.
I agree with that. And I agree with the fact that half-baked things should not be part of this bill, because the whole dynamics then changes. Because if you bring in non-personal data here, then it will completely make the flood of data points coming in. And
Exactly.
there is no stop to it. There's no end to it.
Right, right. Now, see, Srinjoy, in his remarks, he was talking about privacy by design while dealing with his clients and all. So, Arun, what are the challenges that companies will face in implementing this PDP bill? Can you please elaborate?
So I think the first one really is what the co-panelists have spent time on, which is really concerning. Like Napanai ma'am said very correctly, after everyone sent out their 50,000 emails and then realized that for every email you send out asking for consent, you need a mechanism to permit the withdrawal of the consent in the same manner in which the consent was provided. You need a consent manager framework to determine which of your users has consented, which of your users has not consented. And you need a way to inherit those consent permissions retrospectively. So suppose I say yes today, I say no day after tomorrow, I have to figure out what part of my data processing was consented to and what was not. Once people realized all of this, in Europe, they started looking for alternative bases of processing. Now, one of the biggest bases of processing that's used in Europe, and what a significant amount of business is done using this basis, is the basis of reasonable purpose. So when you need to process the data of an individual for a reasonable purpose, and reasonable purpose may include providing services, fulfilling the purposes under a contract, etc., you have the ability to process it without consent. And that has been a strong underpinning for several pieces of guidance that both the Article 29 Working Party has put out, which has now become the Data Protection Board. There is also guidance which has been put out by the various information commissioners in various jurisdictions, basically talking about the ambit of the phrase reasonable purpose and what can be done under it. The second basis which is used significantly in Europe is the concept of contract. Contract is a very important basis under which data can be processed. That basis does not exist under the Indian legislation. The Indian legislation only talks about consent. If you ask Justice Sri Krishna why he did that, he will say because contracts have a tendency to bundle multiple consents, and therefore people will sign anything, and therefore it becomes difficult to walk out of the contract. But the third thing that's missing from the Indian framework really is the concept of processing for employment. Now, there is a concept of processing for employment which is permissible today, but that is only permissible under circumstances where consent is not possible. So it's basically an exception to the consent requirement under the PDP bill. These, to my mind, are three very key obstacles for operationalizing the privacy framework in India. Like Napanai ma'am said very correctly, we are starting from less than zero as far as privacy is concerned. It's not like you have a framework, people are enforcing it. In this market, you can go out and buy people's names and phone numbers for several paise. You can go ahead and buy medical records for several rupees. And this is openly, freely available in the market. You can buy what you want. You will get fairly good data as well. So in fact, I've seen people start startups, go ahead and buy hundreds and thousands of records and then start arranging them in different ways to start using them. In this framework, you take such a very difficult and unwieldy mechanism, which is putting so much pressure and so much weight on the single point of failure, which is consent, and you start running into trouble. So I see that as a very significant obstacle for people in this new framework. The second obstacle, and to be fair, to take a balanced view, there is the concept of a consent manager, which has been incorporated under Indian law. So there is the possibility that consent managers may come in and do something innovative to save the day, but that still remains to be written, that still remains to be seen on how that is actually implemented. The second pain point I sort of see really here is the level of involvement of the regulator. Whether that is to approve and review a privacy by design policy, whether it is to approve and review a data protection impact assessment, whether it is to determine whether or not an instance of data breach has sufficient materiality to require notification to end users. All of these things, which are typically done suo motu by the data controller in Europe, are required to be done by the Data Protection Authority in India. This is proposed, this is creating, and regardless of how big, how powerful, how fantastic the regulator is, on this, he's wearing many hats, and he has to have many hands. And this is going to be very difficult for any regulator to do. Even if we follow the great Indian approach of regulating the largest, most visible players first and hoping the others fall into line, it will still be a monumental mammoth task, because a lot of this will have to be written. So I think that organizations are going to face a significant period of regulatory uncertainty. Now, to compound this in wonderful fashion, what the government of India has done while amending the bill is taken out the implementation roadmap. One of the nicest things about the bill, and I told Justice Sri Krishna this, that I cried a tear to see this go, was this 18-month time frame within which the bill would sort of come into force, or sections of the bill would come into force once the bill was enacted. Today, if a client says, Arun, what is to stop the bill from being enforced in full force tomorrow morning? There's nothing. What is to prevent the bill from coming into force entirely by way of an ordinance tomorrow morning? Nothing, right? The ordinance route was blocked earlier because of this 18-month runway. Now that 18-month runway is gone. So to my mind, these are extreme, the uncertain. I'm not saying this will happen. I believe there are, and we've had discussions with people, even members of the committee, the select committee that's examining this, have said that, look, we will do a phased implementation like we did the CCI Act. We will do a phase-wise notification of this bill. But while that may well be true, there is still an element of uncertainty. There is an element of lack of clarity around this. And I think that will add to the complexity. I think the third and last piece I want to highlight is this right to be forgotten. Now, the earlier bill, the committee bill, basically had a adjudicated right to be forgotten, which is basically you go, you make an appeal, you say that this has to be removed, and then it gets removed, right? Now, there is this right of erasure, which has sort of been backdoored in. And then there is still this right to be forgotten, which is still hard-coded into the legislation after adjudication. This right of erasure, if you remember what happened in Europe after the Google Spain decision, after Costeja versus Spain, the Googles of the world had to go and hire tens and thousands of people to do manual removals from their metadata when somebody sent a right to be forgotten request. Indian data processors and data controllers are not used to talking to data principals. They are not used to having this day-to-day thing. The grievance officer, half our clients don't appoint. They only appoint after they get notified in some due diligence or something. Boss, you don't have a data protection officer. That's when they notify somebody, and that person is whoever has the usually either the poor general counsel, or it is someone in the IT department who's become a de facto CISO. They're effectively notified. Now these people will have to start taking data protection requests. These requests may include erasure, it may include correction, it may include various other things which may need to be done. And that, to my mind, is going to be a very large burden. And lastly, very lastly, is this concept of a fiduciary. Very unique Indian principle. I think the intent here was to create a certain relationship of trust between the person holding the data and the person giving the data, basically saying you're holding this for my benefit, etc., etc. That being said, realistically speaking, what does this fiduciary duty entail? So suppose I collect data in accordance with a purpose that is permitted under law. I get your consent to do something with it. I store it and retain it in accordance with a privacy by design policy, which is certified by the Data Protection Authority. And I have a consent notice which is sufficiently detailed. I've met all of those boxes, but yet somehow I'm not acting in your best interest while processing that data. Am I in breach of my fiduciary obligation? I think that's a very interesting question that currently exists the way the law is drafted. If we consider this a terminology thing and rest easy, then my concerns are unfounded. but I would be very hesitant to be a data processor, to be dragged up to court saying, I'm a fiduciary, but since I've followed the letter of the law, I am no longer exposed under it. So those were my key points of concern. That's what keeps me up at night.
Thank you, Arun. Now, whatever Arun is trying to say, if I take one by one, so first thing he is telling that it is difficult to for companies to segregate such personal data from sensitive personal data while processing, and there is a dearth of people who will be doing it. Sanjoy, do you think AI or machine learning will be a help in this kind of data processing?
In terms of consent, I think what Arun was talking about was consent managers primarily, and consent managers is an animal which is a bit different completely. So the way that I understand consent managers, it is just a layer. I am a data fiduciary. If Arun becomes a consent manager, or Arun or company becomes a consent manager, they are the data processors for me as a data fiduciary. So there I have a problem in the entire consent manager framework that is there. Now, in terms of AI, I think the whole point would be that profiling has to be dealt with a bit better in the act for it to really be effective. My view is that unless there is an AI policy, unless there is something that is supporting the data protection bill and how the profiling is, because there is a tendency of allowing, if I read it correctly, there is a provision which allows a sandboxing to happen, and the sandboxing is nothing but you can take that data and churn it for 1 or 2 years and then anonymize it. Is the fact of how the data operation happens. So my concern is that AI can help, but it would all depend on how the bill is redrafted to that extent. Ma'am, you might have a contribution.
Ma'am, yeah.
No. It's not like I have a contrary view on every aspect of it. So,
Okay.
I'm good.
Sanjoy, if we take it forward, if in your role as a consultant, what are the aspects that you have seen to trouble your clients, if I may put it simply?
Yeah, to put it simply, I think there is, and this is what I speak about in many of the conferences that I go to, is the entire dynamics of how we as Indians look at privacy or data protection, and as Europeans, how the Europeans look at it. So we are very private people, but we share our data with anybody and everybody. So in a chain, and if you are a young boy, a bachelor, or a young girl, unmarried, by the end of it, if there's an elderly gentleman on the other side or a lady on the other side, maybe you'll get a relation set already in the village or in the town. So that's the extent of sharing that we do. In terms of Europeans are a bit different. Europeans are not at all private people, but their data is very, very key to them. So one of the prime things that we need as a country is to understand, and there has to be a drive for awareness of data protection throughout the country, because the whole people may call this an elitist concept. Data privacy is only for a few, not for everybody, but it is everybody because of the whole dynamics of how the world is changing from an offline platform to an online platform. From an offline platform, you could still claim that. But when you are going online with everything, whether it be your Aadhaar card, whether it be your car registrations, whether it be your cash, how you pay. So everything is in that sphere, everything then becomes in an online platform, and we have to be concerned about our data. That's one. That is a concept that even companies need to be aware of, companies need to understand. And unless that is when I'm dealing with clients, perhaps even before starting off on a data privacy impact assessment or a privacy by design framework or anything, is this awareness building that has to happen. So there are some edutech companies that I'm working with, and one of the things that I spent, say, weeks on is the fact that there is a concern about IP. There's a concern about information, your information itself that you are collecting or you are getting. So those are concerns that have to be, that the clients typically don't quite understand. Then the whole dynamics over there is we have to build for them the fact that whereas GDPR may take care of a substantial portion of what they think has happened or whether they are compliant or not, GDPR is not the end of it. The PDPB, the way that it stands right now, there are aspects of it that needs to be brought in by us. So that's a point of concern.
Srinjoy, another thing which Arun said about the data fiduciary. So what are your thoughts on usage of the term data fiduciary? Do you think this implies inherently a higher threshold of care over and above the specific requirements under the PDP bill?
So I think in terms of data fiduciary, I felt that it was a very good terminology that is there. Data fiduciary puts a point of trust between the principal and the fiduciary and the principal. So there is a principle of trust. Now, if there needed to be one more step to it, there needed to be a step wherein the government also is part of that data fiduciary aspect, which unfortunately with the number of exemptions that are there is not there. In terms of how, whether it is going to be sorry, I missed the question. What was the question again? Over and above the PDPB?
Yeah.
No, so let me try and restate it. Basically, what I was saying is if you meet every other requirement under the PDPB, you have purpose, consent, you've done all of those things, you've checked all of those boxes, but yet you're not acting in a fiduciary capacity, you're not acting for the benefit of the data principle. Your act of processing is such that it's not for the benefit of the data principle. Are you in violation? So for instance, credit rating. I'm rating your credit. I have done everything. I've taken all those 15 things that I have to do. But based on that analysis, I determined that you can't get a loan from me, right? Is that in my interest? Am I acting in a fiduciary capacity to you? I am curious as to how this word fiduciary will apply.
Yeah, I think I think ma'am was wanting to say something.
Yes.
No, I just wanted to come in to say that we cannot get carried away with semantics when we are talking about an enactment. You have a definition very clearly in subclause 13 of who or what is a data fiduciary. And it very simply and in a limited way says, and by the way, Srinjoy, I know you did not mean that the state is not included in the definition, but the exemptions dilute the inclusion. Yeah. But for the sake of the listeners, I'm just qualifying that state is very much part of this definition.
Absolutely.
But look at the limits of this definition. It merely says state, company, any juristic person or entity or individual who alone or in conjunction with others, and here the others would be the data processors predominantly, and it could be others too, determines the purpose and means of processing of personal data. So my take on the data fiduciary aspect is that it is a little misleading. You know, the data principal who reads it may think, oh, it's putting it at a much higher threshold. It's data fiduciary and not just a data processor. So my interests are better protected. And then you go to law and definitions, and that's the only thing the courts or any of the authorities are going to look at. And you realize it's simply somebody who determines, they decide the purpose and means of processing of personal data. And the only limitations for that processing or otherwise is what is again set out in the Act. So really speaking, the usage of the word fiduciary does not really increase the threshold to any manner unless otherwise decided through judicial interpretation. And in deciding through judicial interpretation, courts will only go by what is set out as the legislative intent. They cannot go beyond the words. If it had been a phrase which is not defined, then one can understand that the general ideas of fiduciary relationship would apply. But given the precise and specific definition, which is not an inclusive definition, I don't see how the threshold is really increased. At best, I would say as a data subject or principal, I may get misled by the use of the word fiduciary, but really it's not increasing the threshold for the processors or the data fiduciaries as is defined here.
Just one other concept which may guide a court and interpretation, and I fully agree with you. I think this is a bit of little bit of transactional judo. You know, basically you say fiduciary. There's a 4 paragraphs in the committee report about the concept of fiduciary, how we in India think about it differently, etc. But very little of it seems to have come into place in terms of actual tangible obligations. But the other word they've added is in section 4. So apart from being reasonable and lawful, you also have to be fair. Now, fair is again an interesting phrase, right? Is it fair for me to deny you credit because you haven't paid your last 3 loans? Is it fair for me to deny you insurance because you have a pre-exist, you're a heavy smoker? Is it fair for me to not take a particular view that you take into this thing because you are biased in a particular direction? You know, this again adds a bit of gray to it. But I agree with you, ma'am. I think largely this is textual. I shuddered, like I said, I would shudder to go before the Supreme Court of India and say, listen, I'm a fiduciary, but this is all I have to do. That being said, you can very well make that argument in terms of literal interpretation.
Arun, see, while ma'am was dealing with the segregation of significant data fiduciaries, she referred about the data principles mainly. So do you think in terms of the rights of data principles that they have been dealt with properly in the bill? Arun.
So I'm going to try and sort of wriggle out of this one to some extent. I'm not a constitutional scholar. I think the Supreme Court in the Puttaswamy case outlined the elements of the right to privacy and the extent of the right to privacy very, very beautifully. Unfortunately, in the second Puttaswamy case, they took that and applied that in a manner which perhaps was not as majestic. That has been, to my mind at least, somewhat further narrowed by the 2019 iteration of the bill. But without going into whether the bill in its fullness protects the rights in every way they would expect to, I would want to start off by just saying that it very significantly increases the rights and abilities of data principals as available under law. By having an independent adjudication mechanism, by requiring people to have a process for withdrawing consent, by having a mechanism where people are able to directly write to their data controller and ask for certain things, by having this all-powerful, godlike regulator who has the powers of a civil court, criminal court, everything known to man, overseeing the whole area with the ability to hit you with a stick that is 4% of your global turnover. I think this bill, at least from a framework perspective, significantly empowers data principals. I think in certain areas, and I alluded to this briefly, breach notification, the right to be forgotten. I think there are certain areas where this bill is tight. It tries to basically leave the decision on what is okay and what is not either to the data protection authority or worse yet, the data controller. And I also think that there is a real risk that because parts of this bill are somewhat unwieldy. So for instance, this whole consent piece, right? Because you believe that you have to take, so on an average, if I actually sit down and take a standard privacy policy that's put out by any major e-commerce platform today, I will find about 13 different consents which are bundled within that privacy policy, right? And if I am collecting financial information, which is sensitive personal data, at least 10 or 5 to 10 of those have to be explicit consents and granular explicit consents, which mean you not only have to take the top level consent, you have to take the second, third, fourth level consent saying, I can use your bank account information to market another service from my associate company, you know? So this consent framework is extremely big and heavy. Now, one of two things will happen. Either we will see a very competent regulator putting out some very real life standards. Those standards will be validated perhaps by industry associations like yours, or the FICCI or NASSCOM or whoever. They will have a practical formulation of best practices around consent and privacy by design. That will be adopted by the regulator, and then the market itself will move to a more granular framework. Or like all impractical legislations in India, this will lay by the wayside. No one will follow it. No one will enforce it. A few people will get fined, and then it will lie by the wayside. To my mind, I think that is a real risk for data subjects, just given the way this is drafted today. And the next few months are going to be very interesting times for all data privacy practitioners, just in terms of how the rubber hits the road on this.
Okay, Arun, in that case, what you are trying to say, all these online agencies through which we are doing all shopping and everything. So this COVID has also brought to the fore privacy and data protection issues. So, ma'am, I would ask like you to answer this question. If PDP bill is passed, do you believe that these issues will be addressed?
See, look at what all has happened. You know, on one front, what surprised me was the extent to which governments, particularly state governments, have really intruded on people's privacy. The whole issue of right to be left alone has been thrown to the winds. You know, there was this one Karnataka circular which said that people who are now being quarantined have to report through photographs or something from their houses every hour, etc. That's almost like it's worse than what happens when somebody is on house arrest. So on one side, you have governments which have thrown all those issues, what Arun was mentioning, the Puttaswamy judgment, laid down such elaborate thoughts and constructs with respect to privacy. And yes, my specialization is constitutional law, so I can talk very confidently on those aspects. And then you have the flip side, where a PDP bill is pending for nearly 3 years and still counting. And then governments have gotten into all kinds of acts which have been very intrusive on privacy. But this is not what concerns me more. What does concern me more, and what Arun has been saying keeps me awake in the night, is the fact that the individuals involved who are supposed to want this privacy, who are supposed to want the legislation to protect their privacy, are the ones who talk very elaborately and eloquently in all these WhatsApp group or the WhatsApp Academy, as it's been recategorized, on why it is necessary to intrude on people's privacy. So, you know, earlier in the conversation, there was this discussion about how India is not really equipped to deal with data protection laws. And let me tell you, it starts at a very, very grassroots level where we have not even understood why we need data protection. Only when we understand why we need it and what is privacy and why we should respect it, whether it applies to us or to others, and only when we are able to raise our consciousness and voices to ensure that it is protected, can we talk about whether the act will be effective or not. Because today, what are we looking at? And this is what I was referring to in my opening remarks, the exemptions. So we are on one hand talking about data protection. And like I told you, that's why I started off by saying that the data principal was supposed to be the hero, right, of the play. But we are barely relevant to the whole scenario. We are just almost like, okay, without us, you can't have a data protection law, so we will add you as part of the cast, but you're not particularly that relevant in terms of, how we want to deal with your data. So we will kind of like, decide as and when we should give you some significant role. That's how it seems to be playing out. So when we look at all the exemptions, thankfully, part of Article 19.2 has been left out, which is decency, morality, defamation, etc. So predominantly, if you look at what they've done with respect to the exemptions, for government to do away with the provisions of the Act when it comes to issues that pertain to protecting the integrity, sovereignty of the state, etc., etc. They just draw from Article 19.2 in terms of what are the exemptions they can bring in, and then say under these provisions, we do not have to comply with the law. Now, will those provisions apply to an emergency situation is an issue. So I would very simply remind all of us of only one thing. The judgment, ADM Jabalpur, which was set aside by the Puttaswamy, the first 2017 Puttaswamy judgment, was actually of very great significance for all of us as individuals. What it decided was, when we had our only emergency sales, when India was put into emergency and our fundamental rights were parked, the whole issue that the government took, the stand that the government took was that during emergency, individuals are not entitled to claim their rights of fundamental rights. So what Puttaswamy unequivocally set down, which was of course already set down in Keshwanand Bharti, Minerva Mills and various other judgments of the Supreme Court, was that fundamental rights are inherent to all of us and it cannot be tampered with even in cases of emergency. So all I would say for us as individuals, for us to have that consciousness about privacy is, what Puttaswamy did was not give us the right to privacy. It acknowledged that we had the right of privacy. So once that acknowledgement has reinforced our right, and these are hard-won rights, we ourselves, because of fear, should not set it aside. We also should not ask others to set it aside. We should continue to exercise and enjoy our fundamental rights irrespective of what the situation is. Let us not allow fear to rule. And hopefully governments will remember this and will maintain that Lakshman Rekha.
So I just want to chime in here very quickly to be contrary as always. The Bangalore Police Commissioner made a very interesting statement. He said if you break curfew when you go out, you'll get arrested and you'll get thrown in jail for under 188 or whichever section they pull out of their hat. Now, eventually a court may decide to look at it and grant you bail. Most of these sections are bailable. You might get bail when a court looks at you. But where are the courts during the shutdown? Only some bail applications are being heard on an emergent basis. Most of them are not hearing it. So until the court reopens, you're going to be in jail anyway. So I think the fact remains that the machinery surrounding the exercise of justice and the machinery surrounding the restriction of the executive powers is in, to some extent at least, in a state of hiatus. I know Bombay High Court has recently started online hearings. Some of those were bail applications. So hopefully, that balance to some extent is skewed, and we should all be aware of that. Second, even in the home of data privacy, even in the home of data protection, in Italy, in Europe, in the UK, data protection information commissioners have looked at data tracking and monitoring in the context of COVID, and they've taken decisions which, at least to my mind, were extremely aggressive from a European perspective. While some of them have discouraged private individuals from tracking data, like employers and so on, from tracking data, even for COVID management, most of them have aligned with allowing governments to do aggressive data tracking in the context of contact tracing, in the context of tracing, people who are breaking quarantine restrictions. Those are situations where they have allowed for aggressive profiling and aggressive use of technology to track cases. The last point I want to leave you with is that all that is old is new again. In Mr. X versus Hospitals, right, the Supreme Court of India examined what would happen when, in that case, the wife was at a significant risk of getting a life-threatening disease, because the communicable person was not disclosing it to her. And the view that was taken in that case is that it is permissible for fundamental right of privacy to be overruled, even in the context of a well-known fiduciary relationship that between a doctor and a patient, in order to protect life and health of another person. So given that context, I would argue that at least there is some precedence to some of the disclosure that's happening. Contact tracing, the installation of applications on the phone to find location history, the tracking of positive cases across India to figure out whom they've met and so on. That being said, there's the Karnataka government's approach of putting everybody, 20,000 names online. And I think that they may find very difficult to justify in a court of law in the days to come.
Yeah, that's exactly what I wanted to chip in on in terms of proportionality. So the whole issue that arises in terms of what is proportionate to the harm that you are trying to avoid, or the harm that it would vitiate or obviate. So given that aspect of proportionality, what is the extent to which even the naming and shaming that happened in one state, or what the government did of disclosing the names, etc., or saying that, oh, you may violate, or 5 people violated, so I will put 20,000 people under the scanner. So if 5 people violated, put them behind bars, take action as per law. How do you justify then violating the privacy of those persons who did not violate the law, right? This is where the issue of proportionality, which again has been very elaborately dealt with in Puttaswamy, comes into play.
Absolutely. And to continue with that thought, I think the way that the government is looking at it is also talking about something called an application called Arogya Setu. Now,
Yes.
privacy professionals are jumping on it because one of the, as I was explaining, the privacy by design principles, and the privacy by design talks about zero trade-off. And one of the things that the Arogya Setu seems to be doing is that it's not zero trade-off. It is right now towards COVID, which is right for the present moment and the present context. But going beyond COVID, when the COVID, this threat ends, what will happen to all that set of data is something that is perhaps a goldmine for the government.
In fact, Srinjoy, today I was also asked for a quote. I think that may come out tomorrow. One aspect is Arogya Setu, which is scary enough. But there are private players who are also doing the same kind of profiling. So the issue that arose was, should the government say only the government has the right to do this kind of profiling and not private players, or should it regulate? I, of course, voted for regulation because I'm always against most bans, But then regulation also will be effective only when it is enforced. What you mentioned earlier, I just wanted to comment on that. You were talking about this issue of privacy by design. So, and you were saying that your concern is that it is just going to become regular compliance. And this is my standard favorite line, that India is predominantly a tick mark economy. So we may end up with yet another tick mark with respect to data compliance, instead of it being conformance where genuinely our rights are protected.
Absolutely.
And that is what I'm coming right back to, even with this COVID issue, etc., which is how much do we really understand what is privacy? Yeah. Each of us as individuals, irrespective of whether we are lawyers or not, non-lawyers need to understand what is privacy and understand why it should be protected. Only then we will have a real data protection regime.
Absolutely. And just to add to that, I think the entire, the value of a startup is in its data, not in whether the application is successful or not. So that seems to be and to what Arun was also talking about, That seems to be the ethos, that your valuation increases because you have a data set.
Yeah.
I would argue that that will change. The moment
Yes.
the data set stops being this fungible commodity that you can buy and sell as you want, when it stops being an asset and starts being a potential liability, when you have Yahoo style judgments being sort of laid down in India as well, the tendency to sort of market services at bottom dollar, collect a whole bunch of unnecessary data, and then sell it on to the lowest bidder, I think that will potentially go away.
Yeah, but sorry.
No, you please complete, Shrunjay.
Unfortunately, right now the reverse is happening because the bill is still to come. People are busy collecting the data.
Yeah.
That's
No.
the lighter side.
Yeah, I wanted to come in because the whole question that Manojji started off with was on governments and data. And you mentioned, Shrunjay, I don't know whether you did it knowingly or you were referring to the Vahini and Sarathi issue or generally, but I just wanted to come in on this aspect. What is happening really with the government and data, right? Vahini and Sarathi are one is the vehicle registration plate data collection and the other is of driving license. The government, at least this is what the news reports indicate, and there is no reason to believe that they're wrong. They seem to have monetized the data of vehicle registration plates and driving license. And these are all data collected as a measure of governance. This is not data collected in a commercial way, the way apps are doing also, right? This is one step worse than what the apps are doing. So a government collects through a process which we don't have a choice but to comply with, because I can't drive my car without my driving license or a registration plate, and you are then selling it for something as nominal as 3 crores. You know, to a common man, 3 crores may seem big, but we all know that for businesses, it is nothing as an investment. Okay. And when we talk about this whole aspect of monetization of data going away, I would say the first in that line should be governments which think that they can monetize data, because the real fiduciary aspect, if at all it is to be implemented at a higher threshold, it definitely has to come in for governments, because they cannot be heard to say that as a person who is collecting the data, I'm entitled to do whatever I want with it. Even if it means that they are selling it as anonymized data, it should not be permissible, because that is not the job of the government. Government's job is to govern, not to become an industry.
Absolutely. And to that point, I would rather add that it seems that the government has seen that this is a gold mine that is there, and it is replacing the business with government. You can just replace the two terminologies and still come to the same conclusion. You are very right that this has to have, there has to be a dynamics to that. That has to be looked at. Governance rather than collection of data.
Yeah. So Ma'am was talking about the privacy issues in a lot. So see, we are doing this session on Zoom, and this platform itself has been at the receiving end of privacy issues. So there are intrusive technologies everywhere. So how far are we protected in this regard then?
See, this is where the PDP bill will actually come in very useful, sir, because once you have your PDP bill, then you can file a case against Zoom for violation of your privacy rights if it has done it without prior information and intimation to you and without your consent. Whatever has been accused of Zoom, of violation of privacy rights and also of sharing of data that it has recorded without the consent of the participants. And I'm hoping that they are sharing this also, and the persons who are hearing this will be duly warned that they are in violation of laws here and that they can be sued here, right? So given things like this is why we need our PDP bill, and we need it fast, but we need something which is going to be workable and effective, and which is not going to end up in resulting in violating further individual rights instead of protecting it. So yes, one, Zoom, if it did what it did, and if it is proven to have violated even the contractual rights, then it is in trouble. even under the existing law, it can be hauled up. Forget about the forthcoming law, but under the new bill, we have much wider scope for roping in such instances. It's not just Zoom. Take any app. How many of us really check what are all the things that they are taking access to? If it is an app that is checking on your health, why does it need access to your contacts list? Why does it need access to your microphone, to your camera and location services and whatnot? So this is how much we give away without even thinking twice. So anybody out there, if you have the option of using a browser versus the app, use the browser. Don't be lazy, because I always say the real enemy of privacy is not surveillance. Surveillance happens and we can still deal with it. The real enemy is convenience. Because for the sake of convenience, we are too lazy. We don't want to keep switching on and switching off our location services, so we'll leave it on. Who cares whether Google knows where I am all the time, right? So this is how we go about it. And we need to therefore remember that convenience comes with a price, and be a little cautious in terms of how we use technology. On one hand, I always say that developers have to focus on responsible technologies, and we have to focus on responsible usage of emerging technologies.
So here, to be on a lighter side, if I have to say, see, there is a facility in Zoom of recording the entire this session. And if I put it on a YouTube without consent of all three of you, then that will be a violation.
Well, we will formally give you consent here and now.
Absolutely, absolutely. And to add to what Napanayaman was talking about, unfortunately, ma'am, even Google, even if you switch off the location services, it still tracks you. So that is the extent of surveillance that is happening. And
absolutely, that's why you're able to find your way using geotagging even when you don't have data connectivity, right?
Yeah,
but
absolutely.
This is exactly what data protection bill is supposed to protect us against.
Absolutely. The other thing that Zoom is facing also is that there are security issues. So yesterday, my son was having a Zoom session, and there were 24 participants to start with, and we got a 25th participant. So we were concerned, because that is one of the problems that Zoom has, that there can be participants who can join in and do things, mischief, bots and things like that. So that's the extent to which there is no panacea for this. There's no medicine, or as in the pandemic wants a vaccine for this.
Okay.
But no lockdowns because of that.
Yeah, absolutely. We are locked down.
So in the earlier conversation, you spoke about the sandboxing or consent manager regarding that. So is there something interesting concept in the revised bill such as sandboxing? Or
yeah, so I think I have already dealt with it. Sandboxing in terms of security was a principle which talked about, for example, if you have your corporate emails that are there, sandboxing was a place in the mobile wherein you can, the corporate entity or the business can look at it and delete that data once you leave the organization. So sandboxing was that concept that is there. Now in the PDPB they have brought in, and in fact that's a good concept to bring in, but the only if and but as I was talking about is the situation that the startups are getting a lot of data. So what are they doing with that data and how they're using that data is a point of concern. So that's an anonymization aspect that needs to be looked at. The other concept is obviously the consent manager. My take on consent manager is it is just adding a layer. It is doing nothing else. It's there is a concept of data fiduciary, and then there is a concept of data processor. A data processor is a person who does not look at the purposes and means, but is acting on behalf of the data fiduciary. So the consent manager, to my mind, is exactly that. The data processor will be a consent manager will be a data processor, and who will be acting on behalf of the data fiduciary and will be collecting the data principals data.
Arun, what is your take on this? Arun is adjusting his camera. Arun bhai.
There's, sorry, yes. So three things. One, I want to pick up on anonymization and de-identification. I think one of the interesting things about anonymization is the increasing frequency of it, especially from government and regulators and as well as some private individuals. Anonymization as currently defined under the bill is irreversible anonymization. Irreversible anonymization, there are many mathematicians who will swear is a fiction. Given enough data sets which are available, given enough processing power, which is tending towards infinity, any piece of information, no matter how sanitized, is capable of being referenced with other pieces of information which are publicly available to be able to identify an individual. This is the same thing as the rather trite definition distinction between personal data and sensitive personal data. So to give you an example, my image is personal data, right? And if I do this, it's personal data. If the camera is of sufficient quality to scan down into my finger and get a fingerprint of it, that's potentially sensitive personal data because it's biometric. Or if you can get enough resolution of my face to be able to use my face for recognition, and you can see that technology already being deployed. There are cases in China, of course, we've heard they've managed to get around the face mask issue. They've basically got facial recognition that can find enough points in just above your nose to be able to recognize you. There is talk of this having happened in India as well in the context of the recent sort of civil disturbances. But basically, the moment any piece of information can be processed enough to make it sensitive personal information. Similarly, any piece of information which has been anonymized or de-identified can be processed enough to make it identifiable. So whatever frameworks we define, and I think this is one of the key weaknesses of the GDPR, whatever frameworks we define have to have some sort of practical bright line test beyond which people will be able to use data. Or they need to go with the approach that, look, people will never be able to use data and you will constrain industry to that extent, as opposed to the rest of the world where data may flow more freely. Now, as we are aware, while we might be a less global world than we were 2 months ago, we're still a very global world, especially when it comes to information and the flow of information-based services and information-enabled services. So there is obviously a tendency for arbitrage. Under the existing Information Technology Act, there was a clarification which MeitY had to issue at the last minute, basically saying that if organizations are processing the data of individuals under contract, they won't be bound by 43A and the restrictions under it. A similar restriction, similar potential for a carve-out has also been put in the new PDP bill. Basically, for processing of data of non-Indian persons under contract, you're basically excluded. But those, to my mind, are artificial distinctions you are creating either by contract or by law. Fundamentally, you need some sort of bright line test like a HIPAA 18++ standard saying that, look, if you meet the standard, you're going to be able to use this data freely. So that's really on anonymization. Second, just in terms of the concept of a consent manager, I slightly disagree with Sanjay there. I feel that when, I think at a certain point, the difference will be a difference of degree than a difference of kind. Because if as a consent manager, let's look at it in terms of an operating system on your phone, right? If I give my Android operating system permission to allow all applications to access my gallery, all applications can access my gallery. If I give, and the operating system intermediates the application level permissions, right? So a consent manager will sort of act like that. You can, at the consent manager level, set your permissions for all sorts of things. You can say, nobody can use my health information to market services to me. Nobody can use my travel, my locational information to be able to see my insurance premium. You can basically start having broad granular consent protections there. If this framework is done properly, I feel a consent manager will end up becoming, to some extent at least, a processor, because a controller, because the consent manager will not only have to determine what you can do with the data, but to whom it gives that information. So basically, this will be a one-to-many kind of organization with whom anybody can ping, saying, like a KRA agency or somebody who does KYC on a global level, globally where organizations can ping saying, listen, is Arun okay with his healthcare data being used for this purpose? I would see that as the logical last step of this evolution. But that's just my perspective. Perhaps I'm being a little too optimistic and futuristic about it.
Enjoy.
Yeah. Yeah, I think we'll have to wait and watch on this. But the whole dynamics will be, see, the way that data controller and data processor is framed in the GDPR talks about anybody who's having the ability to chime in or to decide the purpose and means. The purpose and means is very important over here. Anybody who's able to do that will be called as the data controller or the data fiduciary as per the Indian context. And anybody who listens to the data fiduciary and follows the rules and the guidelines of the data fiduciary becomes the data processor. Here in this context, there might, as Arun is saying, there might be a situation wherein a potential data processor becomes a data fiduciary and consent manager becomes a data fiduciary. But in 90% of the cases, it will be that the data processor will always be working on the guidelines set by the data fiduciary. Rather, the data processor will be working on the guidelines set by the data fiduciary. So there is where a consent manager is, to my mind, is a layer that is being added, and which in some cases will make the life of the data fiduciary easier, because the consent frameworks that have to be created for that is being done by a third party, is not being done by them.
Okay.
That's how I look at the concept, but again, it'll be tested.
Srinjoy, Arun was talking about all the data regarding fingerprints and your face picturization and all about this. All these things are about regarding the personal data. And we are discussing about the PDP bill, as the name itself is saying about the personal data. So what about the community data, non-personal data, which earlier you have had a passing reference and its protection about it? How you are going to go ahead about it?
So as we were discussing, I think we had a detailed discussion on this, but I believe the non-personal data, concept of non-personal data will have to be dealt with separately from this PDPB bill, and that's how we'll have to work on it, because it, as I was talking about and as ma'am was talking about earlier, if we bring it into this concept, into this act, then it will just cause havoc. There's no end to the data sets, because personal data in its capacity is anything that identifies you as a person. So these are n number of elements that are there. So those n number of elements can be personal data, can be sets that have combinations. So we'll have to deal with non-personal data completely separately. The Gopal Krishnan committee is already looking at it. So I think that's the way that it will go.
Yeah, ma'am.
Yeah, I wanted to actually touch upon this aspect about facial recognition technology and capturing of images, etc. Now, when you look at the international construct, you will see that particularly UK, if I can take that as an example, it was one of the earliest to come up with a specific law for CCTV footages itself. I have covered it in my book, Technology Laws Decoded, as a separate entire section itself on that. Now, it talks about how CCTV cameras can be fixed, even if it is in your personal premises, in your office, etc., or in shops. What is the usage that kind of data can be put to, etc. And that is really providing for privacy, I would say. When you take into account laws across the world, let's say for drones, the primary concern they talk about, one aspect is of course security and security of nation, etc. But the primary concern you will see is again of privacy. So for instance, Germany's laws on drones talks about how you will not allow for a drone to fly and take for pictures or video 200 meters of others who would not have, in a crowd where they may not have given consent, etc. So when we talk about these kind of intrusive technologies, and we are talking about what has happened in China with facial recognition technology, and what is being now adapted in India, it is a very, very worrisome process. Firstly, India seems to be acquiring all of its facial recognition technology under the guise of protection of women, because they are using funds in some states that have been given to them under the Nirbhaya Fund, which is purely for protection of women and children, etc. The second aspect is the assumption, therefore, that seems to come into it is surveillance is a good thing for you, because when we surveil you for 24/7, we will ensure that you're being protected. That is the distinction that law and constructs policies draw with respect to what's protection and what is protectionism. So I believe, though we already have too many laws, we have a proliferation of laws, and what we lack is implementation. But when it comes to issues like facial recognition technology, I feel that there has to be specific provisions or laws to deal with it. PDP bill, and this comes back to what I was mentioning earlier about the exemptions and how it can be misused in its current form. It earlier said that you can have exempt the provisions of this law in terms of capturing data and its usage. It is specifically like government can be exempted provided it is through a law passed by Parliament. Now it says governments may be exempted on various XYZ grounds. Now the distinction that happens is what happens with facial recognition technology. Will it be considered part of an exemption, or will they be still bound by the PDP bill provisions with respect to privacy and data protection? This is a moot issue which is just hanging in the air, and my concern is it would be treated as an exemption.
Ma'am, yeah. Yes, Srinjay, you want to say something about?
I think just to add to that point, the bill is a bit of a feast for the government, so to speak. So it's got 70% GDPR, that's the rice. And then there is a Chinese tadka of surveillance. And there is, and the strictest masalas from all over the world have been brought in for the added flavor. So it seems, just to agree with you, ma'am, and agreeing with you, there seems that I think surveillance, through national interest, through whatever means, and the protection of women, they have taken the route that they can't take in India in terms of the same way as China, but they've taken a circuitous route back to that same thing.
So ma'am was referring to the protection of the data pertaining to women and children and all. So ma'am, what is your take on how children's data is being looked in the PDP bill?
See, that is one aspect where they come in very strongly. For instance, if you look at the US provisions under COPA, they have a separate enactment to deal with protecting the rights of children. But when we are talking about the provisions under the PDP bill, they have broadly drawn from COPA on the aspect of ensuring I'm sorry, I'm running out of charge, so I'm just getting my phone plugged in. Yeah. So you do have a strong two-factor authentication process of parental consent, etc. coming in. And there is this aspect, one more kind of data fiduciary comes in under this provision called the guardian data fiduciary. So when you look at the provisions for the guardian data fiduciary, there they come in completely with a blanket ban on all kinds of things which can impact children, including profiling of children. So this is what I was talking about earlier, that on one hand, the law very clearly says no question of profiling children by guardian data fiduciaries. But on two counts, it fails to pass the test of, the threshold of protection. The first one is that in the definition of guardian data fiduciary, it is very open-ended. It is all the online platforms, etc., which may be collecting children's data predominantly. And the second part of it is any other kind of online platform where there is a, or any app, through any app, etc., where a large volume of data pertaining to children are being collected. Now, what is large volume and what amounts to, therefore, the guardian data fiduciary is very ambiguous. And one of the queries that has been raised in the chat session, I saw this issue about a large part of that act being ambiguous. And I suspect that it is so for a reason. You know, what seems to be the intent and purpose behind this ambiguity is that whatever the law is ambiguous on can be provided for in rules, which is a good thing. But the bad thing about that is rules is delegated legislation. And therefore, you're going to get a lot of rules which are going to be laid down by the executive rather than the legislature. So ideally, law should still be precise, and within those precise parameters, regulations have to be enacted. So on the definition of the guardian data fiduciary, it is lacking. And the second aspect, what about the other data fiduciaries? Why is it okay for them to do profiling? And that seems to have been missed out with respect to protecting children under the Act.
So do you mean that Data Protection Authority is rightly constituted? If I may go further in that.
Sorry?
So do you think that the Data Protection Authority is rightly constituted to do all these things?
Well, that is a different issue altogether. When you look at the manner in which the change, some of the largest changes has happened with respect to the Data Protection Authority. Firstly, the mode and manner in which the Data Protection Authority was to be appointed under the 2018 Act, which was a combination of the executive, the judiciary, and the multiple stakeholders, as opposed to what it is now, which is like technically 3 ministries of the government. I would say that already we have lost the game in terms of who the Data Protection Authority would be and what kind of powers they would wield. And as I mentioned briefly earlier, the Data Protection Authority also has a lot of powers which include, the right to decide from, even what is privacy by design and whether you comply with it, all the processes and provisions with respect to how a data protection regime is going to be implemented by corporates, who would amount to a significant data fiduciary, who amongst the significant data fiduciaries would become the social media intermediaries. Everything gets decided by the Data Protection Authority. So if you're going to rub the Data Protection Authority in the wrong, you better start praying a lot more than Arun would, right? Huh? You're not going to have enough candles to burn then. So it's a little worrisome the way the Data Protection Authority is structured over here. I think everybody else except the person who will be the Data Protection Authority is going to be very unhappy. And even the Data Protection Authority, I would say, will be in a hot seat, because look at the kind of things that the authority will have to do. There was one concern that Arun raised, and one of the audience also seems to have raised about an ordinance coming in. I wanted to say you can rest assured that no such thing is going to happen, because look at where India is today. One, you have a PDP bill draft which doesn't really provide everything. What it does is it gives a lot of delegated authority to the executive. The executive is then supposed to draw up the rules and regulations, and here, but predominantly a lot of these powers lie in the hands of the Data Protection Authority, and which is why I said he has also legislative powers. And then he himself is the authority who will implement it by holding you liable if you violate it, right? He is therefore the judiciary then. So he does everything. And maybe I should start saying she now as a suggestive measure, right? So anyway, so the Data Protection Authority can do whatever he wants, but then the problem arises that it also is in the hands of the Data Protection Authority to lay down all these rules and regulations and whatnot. So whether it is an ordinance route or an act route, we are not going to see this act coming to light in the near future. It is going to take some time. The Sri Krishna committee draft had a timeline of 1 year, 6 months for the Data Protection Authority to be appointed and for 6 months for rules and all that to be framed and then for the law to be implemented. I thought even the 1 year timeline under the Act was utopian. So on this count, I differ with Arun. I don't think they removed the timelines because they want to bring in this Act tomorrow. They remove the timeline because they know for sure there is no way they're going to be able to implement it within even a 1 year timeline. That's the reason why the timeline is gone.
I hope that's the case, and I'm not disagreeing with you there. All I'm saying is by removing it, I mean, if they removed that 1 year and put in 3, we would all have slept better. Although, arguably, we would have pushed this problem down the road and dealt with it later. But I think the uncertainty of the deletion is concerning.
No, see, but Arun, you're assuming that everybody is only worried about the implementation of the data protection regime and therefore you would prefer a longer timeline. We are all forgetting why was the PDP bill even felt necessary. To begin with, it was actually industry which was pushing for PDP bill. We should not forget that it was because there is a huge business potential between, in terms of wanting and needing a strong data protection regime in India that drove the narrative to begin with. Even today, India is not part of the approved nation list for EU data to be transferred to India. So we are losing a lot of businesses. So we should not forget that industry was pushing for this. And as we always say, be careful what you wish for because you may actually get it. And that's the situation we are in. And we got what we asked for, but not really what we asked for, right? And therefore the balance is still going on in terms of whether this is what you want to grow a business, to get a piece of this pie, which you're otherwise missing out, or whether this is something that is going to become very onerous for you to comply with.
So just on
we have just on that point, I think as an adequate country, we have applied for perhaps 3 times, and we have failed in all those counts because our act was not there, and that's why the industry also stepped in to say that let's get to it. But yes,
exactly,
it may be a difference between what we want and what we are getting.
So interestingly, I was having a conversation with Bruno Giancarelli at the European Commission. Justice A.P. Shah and his committee had made a fairly adroit argument for how our existing Section 43A and the PDP, the IT Act incorporates the principles of data protection and actually has all of the various elements which will enable us to get data equivalence. The adequacy test fell on implementation because effectively we were a negligence-based regime rather than a positive normative regime. So because of that, they were just uncomfortable to say that, look, this was a practical working framework. The other very interesting point that was raised, and this is not the same source, I can't tell you who said this, but a very interesting point that was raised was the Section 35 and the ability of government to requisition data, the ability of the Data Protection Authority to requisition data, the ability of the Data Protection Authority to requisition non-personal data also. All of these things will potentially be seen as infirmities in ensuring the protection and adequacy and safety of data against government. Because if you look at the entire reason the Indo-EU data, the safe harbor was reset and a new safe harbor was put into place and all of that discussion happened, the concern was around PRISM because basically you had the ability for the regulator to step in and just take whatever data they wanted. And we're seeing somewhat similar structures here under the current legislation. So it will be a very interesting adequacy discussion when we actually do get to it.
Absolutely. And one more point on that is what is sauce for the goose is definitely not sauce for the gander here, right? Because we all know what happened with the Maximilian Schrems case and how quickly the US Privacy Shield was put up. Whereas India has definitely not, I'm not claiming that India had all the wherewithal to be an approved nation. All that I'm saying, and in Arun, I have also had discussions, being part of closed door discussions with the Brussels committee members here in India, etc. But the whole issue, as you rightly had said, is we did not even have an implementation mechanism. And secondly, whilst it was a negligence-based issue under 43A, if you look at the rules, actually, it was a positive affirmative action process. It was not negligence-based. So that is where the inconsistency arose between the one sole provision standing for in terms of 43A and the rules under it. But what India did have was 72A, which was a criminal provision for violation of personal information, not just sensitive personal information. That was never played as a very strong card, unfortunately, under 72A, and that's why that failed. But what you pointed out, all the provisions, just to clarify, are under the PDP Bill 2019, and you're absolutely right, and therefore, though the industry may have wanted a strong PDP bill in lines with GDPR, with all these government rights, and especially the one where they can requisition even non-personal data, are all going to stand in the way of India probably getting its approved nation bid. And the reason I mentioned about the sauce for goose is because US still has its Cloud Act under which it can requisition. So merely because it's in a separate legislation doesn't necessarily make it a lighter burden to carry, right? But here, with these kind of provisions forming part of the PDP bill itself, we are likely to lose out on the positives or the benefits of having a strong regime and possibly just carry the burden of it.
So in that case, Arun, how will you take this cross-border transfers and data localization work into the bill? Is this a practical framework then?
So I am going to say something very controversial again. I know there's questions about localization which has come out from the audience. I don't believe that localization and data protection are necessarily related. I personally feel that protection and privacy is capable of being enforced everywhere. Localization, if anything, is a protection against sovereign infringement on privacy, which is only a small subset of the various infringements that occur. And just given the architecture of the internet, given the way in which the networks are distributed and structured, there's many ways to get to that point of tapping into somebody else's data. Localization is often a case of data sovereignty rather than data protection. But that's more of a sort of a catch-all statement. The fact remains that the position under the 2019 legislation is significantly circumscribed from the position under the 2018 draft. There is now a requirement for, especially in case of sensitive personal data, for that data to be an ability for that data to be taken outside temporarily for processing and brought back in. Personal data is effectively unrestricted, and perhaps most concerningly, and this is what worries me a lot, they get this loaded gun of critical data which is pointed at all our heads. There's no legislative guidance on it. When Justice Sri Krishna, I think, was mentioning at one point that their intent was that this was a very narrow category, basically personal information of the President of India, personal information of the Chief of Army Staff, stuff like that, a very, very narrow category of things. But realistically speaking, there's no legislative guidance for it. So potentially you might have a situation where anything can be put in. If somebody tomorrow says all maps of resolution of more than 1 meter is 1 centimeter will become critical personal data, then there are extremely significant restrictions on its operations. No one can even, they're very restricted in the way it can be accessed. If they extend it to things like certain types of financial information or certain types of medical information, it will be even more concerning. So to my mind, that framework is in need of clarity. I for one, am very curious about what critical personal data will be defined as. Second, in terms of cross-border frame transfers, I think, again, there's a checkbox compliance sort of approach here. The GDPR approach of having all of those 4 or 5 mechanisms to transfer data out of India has been sort of inherited into this structure. I would have thought that there is a case for simplification because, realistically speaking, the GDPR is always going to be the dog that wags the tail. It is going to be the basis on which most companies will still benchmark their data protection processes globally. So to my mind, there was an argument for having dovetailed at least to some extent on it. And any sort of significant deviation from a mechanism perspective on how this is done is potentially concerning. That being said, if you have standard terms of contract which are very similar to a processor or processor controller contract under the GDPR, I don't see why per se, unless of course our data protection authority puts out very different guidance. As a principle, you would not be able to make it congruent with something we would put into place under the current legislation. So to that extent, we may be able to have the same thing doing two things. Basically, you may have the same contract able to enable cross-border transfers in multiple directions. But this will again depend on the data protection authority and what it approves.
Yeah. See, time, there is some limitation on the timeline. So it's already 7. Now, one more question, last question from my side. See, we have discussed about the removal of the timeline of 1 year and this and that. So now, what is the timeline for the bill? When do you expect it to be passed, or what can be done while we wait for it?
So I'll take a small crack at this. Pre-corona, somebody on the committee told me, whatever happens, you can take it from us by the end of this year, it will be passed. Right? End of this financial year, it will be passed. Post-corona, obviously the committee itself has now got to submit it in the monsoon session. We don't know if there will be a monsoon session, or for a matter whether there will be a winter session, or whether we'll start off straight away with next year's sessions, or they'll move the parliament in camera. I think there's just too much out there in terms of how these things are going to work. That being said, on counterpoint, I want to point out that the large number of exploits that are happening right now, the significant increase in cybersecurity issues which are being faced by clients across the board, work from home basically increasing the attack surface of every organization around, the amount of data flowing through platforms like various platforms that we use to communicate these days creates an increased impetus for some form of law to be formed. I don't know if that will come in terms of the notification of the amendments to the intermediary regulations, or it will come in terms of some sort of amendment or rules to the IT Act, or it will come under the ordinance route in terms of the PDP bill. I don't know how they're going to do it, but there's clearly a burning need to be able to pull up people for some of the stuff that's being done. And there is obviously egregious breaches which will become more and more prominent as time goes by.
Okay. Now, there are a few questions. Chat box, so you have already read, and most of the questions are answered from the chat box. But there are questions raised by a few people, so I'll take some of them. There is a question from one Ruchika Gambhir. What about the AI image recognition or facial recognition application available in our mobile phones? Are there any safeguards for protecting our invasion or privacy under the forthcoming bill?
I would say that this is exactly why I was mentioning that we need a separate bill, or at least separate provisions dealing with facial recognition technology, because why would it not be open to a manufacturer or an app provider or any other service provider to claim consent as the basis for violating your rights? Right? Because the very fact that you're using facial recognition technology to enable your smartphone or your computer to launch itself without thinking twice about what is that data being used for. Today, you also have apps which talk about how they will clothe you virtually. You have virtual interfaces which will help you to shop where it is customized to you specifically. You have apps which talk about how they will capture your image and then convert it to cartoons. You have apps which will capture your image and then convert it to a video message. How many of us really pause to think about what is happening with all that image capture? On one hand, proportionality aspect, which is brought in terms of consent, also will definitely regulate and can be used in terms of violation or exceeding that right of usage that is being permitted by the data principle. On the other hand, these are still going to be issues which can be decided only through judicial review. So this is where the concern will arise, that until and unless a court decides otherwise, are companies or corporate entities or apps, etc., going to keep violating individual rights? Or should there be something specifically provided for in the law? I would vote for the latter.
So I want to just chime in, from in the perspective of existing law. If the Data Protection Act were enforced today, the collection of the facial image, the processing of the image on your phone, or on terms more realistically on the servers of the cell phone operator or the app provider, would be individual acts of processing. Those acts of processing would effectively have to be consented to in sufficient detail. You would effectively need explicit granular consent for how each of those things were used. So you would need consent for using that image to unlock your phone, to retain it in order to maintain an audit trail, to resolve any disputes arising to it, etc., cooperate with law enforcement, whatever potential sort of end users they have of this processing would need to be expressly consented to. And obviously, there would be some sort of code, the cell phone manufacturer or the app provider, if they have more than a certain number of faces and a certain number of users, would very likely be classified as a significant data fiduciary, which would then mean that they would have to do a data protection impact assessment. They would need a data protection officer. They would potentially have an annual audit being conducted. They would have a certified analysis being done on a regular basis. Their privacy by design policy would have to be certified by the Data Protection Authority. There would probably be insurers in the market who would have some form of insurance to protect them around it. And very likely your ability to use your ability to use this data would be governed by a consent manager whom you would have appointed across whichever phone you use. So whether you're using your iPhone or your Android phone, you would probably have a consent manager whom you said, you can use my facial recognition data for these 2-3 things. So to my mind, there is a lot of structure which is possible under the law. Obviously, again, this is being idealistic, but at least there would be a lot of structure which is possible under the law around this. It's not as if it would be completely bare, even in the absence of a specific legislation, which I fully agree with Napanay ma'am, would probably cover this better.
So another question is, all the contentious issues on the bill relate to ambiguity, giving extraordinary powers to the government. So role of social media, intermediaries and cross-border transfers and storage location of the personal data. The non-contentious parts related to how the small and medium companies need to change or improve their system to become compliant when time comes. Hence, if those points please be highlighted and discussed. Srinjoy, this is your question.
Yeah, I'm just looking at it. So the non-contentious part.
No, before Srinjoy responds, I want to say as a lawyer that every part of this is contentious. If we give Napanay ma'am like a dartboard and point her to this and she lands on any section, there will be 5 things that are wrong with it, and that's just how this bill has been drafted.
Yeah.
It's no Indian Penal Code.
Yeah, so
Well,
I would
considering that.
Yeah, sorry.
Srinjoy, just to add on that, since I was mentioned, considering that I am probably the only litigation lawyer here, I love it.
Absolutely. So broadly, I would look at it very simplistically and look at the principles that go behind data privacy and data protection in terms of how the contentious, non-contentious, the principles stay practically the same. The consent, notification, notice, all those principles, 7, 8 principles that are internationally recognized remain the same. So if you are following those principles there, the only tweaking that you require in terms of the law itself is the nuances of the law. So when I am right now also, I am telling the clients and I'm doing data protection, impact assessments, privacy by design, everything that I'm doing on that basis that you are at least there. You are 90% there. The 10% that will remain is how the law needs to be tweaked once it comes in.
Okay. So even a possibility of an ordinance route makes it even more scary for the companies to get ready in time. So very important for the ecosystem. Yeah, ma'am.
No, ordinance is not going to happen here. It cannot happen because there are lots of things that need to be addressed. Rules have to be framed, etc. So this is not something that anybody is in a tearing hurry to bring in, right? There is no urgency that would come in. Just to add to what Srinjoy was saying with respect to SMEs and or compliance, my suggestion would be do not wait till everything has come up. You already have guidance. you already know that whatever may remain or be deleted from the bill, it is still going to predominantly follow the GDPR route. So given that you already have some indication of how the law is likely to be, what is the harm in being prepared in advance? So I would say be ready, be alert and on ahead of the curve in this case, and get ready today. And there was just a question on an aside, sorry, Manoj, somebody was asking which was the law I was referring to on the CCTV. Mayank, it is the UK law. UK has a law for that. And on your question of ordinance, I don't think that's really going to happen. Meaning practically it would be next to impossible for them to do that.
Absolutely. And just to add to what ma'am was talking about, I think the two-year runway that even GDPR had was less than what it takes to comply with the data privacy. So you're right, ma'am, that it needs whatever runway you can get right now is the runway that you get till the bill comes. And then after that, we don't know what is going to happen. We have closed that.
As the person who sort of raised the specter of an ordinance, I want to clarify that I was using it as an illustration to indicate how the clarity between the 2019 drafts and the 2018 drafts has differed, and that there's less visibility and more fear in the market around it. Do they have 50 lawyers sitting and drafting all of the delegated legislation so that, you know, on the 1st of June, they're going to just say, ordinance, here is the bill, here is all the delegated legislation, now go ahead and start. I don't think so. That's not realistic. At the same time, they have left something open. I, for one, would be much happier if they had prescribed some sort of timeline, just so that everybody knew what to work with. And I fully agree with what Shanjoy said. You know, if someone had gone to Europe and said, you're going to have a period of 2 months when all your operating business processes are not working, all your compliance and your management people are sitting idle in front of a computer, and they have the ability to sit and do a business process mapping, a data mapping, understand how your data are flowing through your system, etc., etc. And perhaps some legal professionals are also less engaged than they would normally be with courts operating and so on. Everybody would treat that as a blessing. You know, and that's the situation we find ourselves in today. I think it would be remiss, at least, not to do some serious thinking about the impact of this new legislation in the time that we have. And you know, I would like to thank Manoj just for having this session during this time, because it's extremely important as a topic to discuss, even though it might sort of get overshadowed by the hundreds of COVID-centric legislations that come out every day.
Absolutely, I would agree. And in fact, my analysis is that many more people are reaching out right now because they have that time, and looking at the clients who are looking at it right now are going to profit at the end.
Right. So due to time constraint, I am now about to close the session. Whatever in the chat box, what is available in question answer, if there is anything remaining unanswered or unreplied, we will try to take it from the individual speakers and get back to you. So don't worry about that. Meanwhile, let me do the formalities. I must thank IMC for organizing this seminar, this session, and thank you speakers for your spending your valuable time and enlightening us with the practical solutions or tips, as I may say, to resolve or avoid possible dispute or claims that may arise due to this kind of a situation, or we may be constrained to do certain things in the COVID-19 situation while using Zoom or other affiliate platforms or applications. Right? I must put it in the on record that I am thankful to Mr. Prathamesh Popat for suggesting name of Ms. Napinai ma'am, Niti Paul for suggesting Shanjoy's name, and Bharat Vasani for Mr. Arun's name for this seminar. I am thanking all of you once again for this wonderful session. Thank you very much.
Thank you.
Thank you so much for having us.
Thank you.
Yeah.
Thank you all who are listening. Thank you.
Thanks.
Bye-bye.
Bye-bye.
Bye.